This video provides a brief overview of the online content classification scheme effective in Australia. The scheme is overseen by the Australian Communications Media Authority, applying Schedules 5 and 7 of the Broadcasting Services Act. Schedule 7 in particular prohibits certain types of content from being hosted or made available by Australian service providers. The Classification Board is the body that is responsible for determining whether content is prohibited or not. Australia has a co-regulatory content regulation scheme. This means that telecommunications providers work together through a body called the Communications Alliance to develop industry standard codes of practice. These codes are then overseen and registered by the Australian Communications and Media Authority, or the regulator. The ACMA operates under the Broadcasting Services Act 1992 in Commonwealth legislation. Under this legislation, Schedule 5 regulates material hosted outside of Australia, and Schedule 7 applies to material hosted within Australia. Media content in Australia is classified according to the National Classification Code. This is overseen by the Classification Board and provides different ratings for different types of content over films, publications, and computer games. Each state has its own regulatory scheme that regulates how people can access and distribute various types of content. Unlike films, publications, and computer games, internet content in Australia is only rated on a complaints-based mechanism. This means that when a person makes a complaint to the ACMA must investigate to determine whether or not that content is potentially prohibited and refer the material onto the Classification Board for final review. When the ACMA receives a complaint about content that is hosted internationally, it is able to investigate, but there are no substantial blocking or content removal provisions in the current industry code. Prohibited content is passed on to filter vendors and other providers to voluntarily block some forms of content, but there is no provision to require Australian providers to block prohibited content hosted overseas. Schedule 7 of the Broadcasting Services Act, by contrast, does prohibit Australian providers from making prohibited content accessible within Australia. When the ACMA receives a complaint about content that is hosted in Australia or has an Australian connection, it must investigate whether that material is prohibited content, and it may issue both an interim and a final notice to providers to cease making that content available. Content that is prohibited in Australia is defined as material that is or would be refused classification, X-rated, rated R18+ without a restricted access system, or audio-visual content that is rated MA15+, provided over a commercial service and not subject to a restricted access system. The classification guidelines provide the content will be refused classification where it exceeds the limits of all other categories of media content. RC content is not necessarily unlawful to possess or access, but it is unlawful to broadcast, sell, or screen publicly. The X-rated category is only for films that contain sexually explicit content. Most Australian states prohibit the sale or hire of X-rated films. The R18+ category is for films and computer games with high-impact violence, sex scenes, drug use, or offensive content. Access to these media are restricted to adults within all Australian states and territories. The MA15+ category is for video games and films with strong level violence, sex scenes, drug use, or other potentially offensive content. These films and computer games are restricted to persons aged 15 years and over. ACMA must make a preliminary assessment of whether material that is complained about falls within these categories. ACMA must also apply to the Classification Board for a final ruling about the classification of the content. If prohibited content is available from servers with an Australian connection, the ACMA must order the service provider to remove or stop serving the content. For hosted content, this means that ACMA must serve the hosting service with a final takedown notice once it hears from the classification board that the material is prohibited content. For live streaming content, ACMA must give the provider a final service cessation notice. And where prohibited content is linked to by an Australian indexing service or search engine, ACMA must give the provider a final link deletion notice. Service providers have an obligation to immediately respond to the notices provided by ACMA. This is enforceable by both a criminal offence and a civil penalty provision. Online service providers can appeal a decision of the ACMA to the Administrative Appeals Tribunal. This is only open to service providers, not to end users that may have uploaded or made the content available through a service provider's network.